If your HOA just fined you $500 for a flower pot sitting on your own front step, they might not actually be allowed to do that. Ever wonder how much legal authority your HOA actually has? And what happens when they get it wrong? Today, I'll explain HOA fines like you're 5 years old. By the end of this video, you'll know exactly when a fine is legal and when it isn't. You'll also learn the specific move that makes most fines disappear before you ever pay a dollar. HOAs feel like they have unlimited power to fine you for anything. Fine you for your lawn, your paint color, your holiday decorations being up 3 days too long. And most people just pay it because it feels official. It comes in an envelope with a dollar amount on it. It looks exactly like a bill from the government, but it's not from the government. It's from a private organization, one you'd technically agreed to join when you bought your home. And that distinction matters more than almost anything else in this video. Quick note, this is legal education, not legal advice. HOA laws vary by state, so check your local rules or pull up your HOA's governing documents. That's worth doing before anything else, and I'll explain exactly what to look for. So let's follow one story all the way through, from the moment the letter arrives. You just got a notice in the mail saying your HOA is fining you $500. Reason listed? Unapproved container plant on front entry. You have a flower pot. A single flower pot. And now you owe $500. It's 7 p.m. and you open the envelope at the kitchen counter. You read it twice because the first time doesn't make sense. $500 for a flower pot. Your name, your address, due in 30 days. Your first instinct is probably panic, or rage, or both. Here's what most people do next. They either pay immediately, or they ignore it and hope it goes away. Both of those responses are mistakes. Here's what your HOA board already knows going in. This isn't a misunderstanding. A well-run HOA board has seen exactly how homeowners respond to a fine notice. The letter is designed to feel final, like a bill you already owe. They're betting you panic before you ever ask a single question. But there are rules they have to follow before that fine is real. And a surprising number of HOAs skip those rules entirely. Let's start with the most important one. Before your HOA can fine you a single dollar, most states require them to give you notice and an opportunity to be heard. That means they have to tell you what you did wrong. In writing. They have to give you a chance to fix it. And in many states, they have to let you speak at a hearing before the fine becomes official. Some states even require that hearing to be held within a specific number of days, meaning a board that drags its feet may have already forfeited its right to collect. Did you catch that? If your HOA skipped any of those steps, the fine may not be enforceable. Not it might be reduced, not enforceable. Gone. It's kind of like a parking ticket with no officer signature. Technically issued, technically meaningless. So you read that $500 notice carefully. No mention of a prior warning. No hearing date offered. No window to fix the issue. Just $500 due in 30 days. That's your first signal something is wrong. Here's where the plot twist lives. Most homeowners assume the HOA's rules are the HOA's rules. Whatever's in the document goes. Sounds fair, right? Wrong. HOAs are bound by something bigger than their own rulebook. They're bound by state law, federal law, and their own governing documents, in that order. And those governing documents have a hierarchy that most people have never heard of. At the top is the Declaration of Covenants, Conditions, and Restrictions, the CC&Rs. Think of that as the HOA's constitution. Below that are the bylaws, which govern how the HOA runs itself. And below that are the rules and regulations, the day-to-day stuff. Here's the part your HOA hopes you never figure out. The fine for your flower pot has to exist in writing, in an official document adopted through a proper vote. If someone on the board just decided flower pots were a problem one afternoon without following the right steps, that rule might not actually be a rule. A rule made up without a proper vote is not enforceable. A fine based on that rule is not enforceable. The whole thing collapses like a house of cards, appropriately enough. So back to your flower pot. You ask for a copy of the specific rule it violated. In writing, email is fine. You want them to point you to the exact section of the CC&Rs or rules that covers this. If they can't do that, the fine is almost certainly dead. If they can, you now know exactly what to challenge. But wait, there's more. Let's say the rule exists, and it's properly in the documents. Your HOA can still run into serious problems. Because most states cap how much an HOA can fine you per violation, or they require fines to be reasonable and proportionate. A $500 fine for a flower pot would fail a basic reasonableness test in many states, especially if they've never fined anyone else for the same thing. That's called selective enforcement, and it's a defense. Imagine your neighbor has 3 flower pots and a garden gnome. The HOA never touched them. Then they come straight at you for $500. That inconsistency is a problem for them, not for you. Courts in multiple states have thrown out HOA fines specifically because the HOA enforced the rule against one person but ignored everyone else. Some courts have gone further, ruling that a pattern of selective enforcement voids the rule entirely. Not just for you, but for every homeowner in that community. Think of it like a speed trap that only pulls over cars of one color. The law exists, but the way they're applying it is the problem. Here's another one. Some HOA fines are prohibited entirely by federal law. Picture this. A homeowner with a mobility disability installs a small ramp near the front door, and the HOA sends a violation notice with a fine attached. The HOA's board sits around a table genuinely believing they're within their rights. They are not. The Fair Housing Act requires HOAs to allow reasonable accommodations for disabilities, including physical modifications to the property. A ramp, a specific doorbell, or in some cases, even a particular type of planter for someone who can't bend down easily. The HOA doesn't get a vote on that. Federal law doesn't ask for their opinion. And if your HOA is fining someone over a disability-related modification, they're not just wrong, they're potentially liable. That's not a fine dispute, that's a federal complaint. So now you have a real toolkit. And let's close this out the way it started. Your $500 fine, your flower pot, and an HOA that was counting on you to panic. Here's what you do. First, don't pay it yet. Second, request the specific rule in writing. Ask them to cite the exact document and section. Third, check whether you received proper notice and a hearing opportunity before the fine was issued. Fourth, look up your state's cap on HOA fines. Search your state name plus HOA fine limits. Fifth, look for selective enforcement. Ask for records of prior violations and fines against other homeowners. In many states, you're entitled to those records as a member. Then you respond. In writing, you reference every issue you found. Calmly, specifically, no emotion, just facts they have to answer for. Most HOA boards, when they realize a homeowner actually knows the rules, quietly back down. Not because they suddenly grew a conscience, because fighting an informed homeowner costs them attorney fees, board meeting headaches, and the very real possibility of losing. It's easier to make the fine disappear than to defend it. Studies on HOA dispute outcomes consistently show that homeowners who formally contest fines in writing resolve them favorably far more often than those who simply pay or ignore them. Your HOA sent you a $500 fine betting you'd never ask a single question. You asked one. You asked for the rule in writing, and that question, that one simple question, changed everything. Here's something worth sitting with. If your HOA has this much power over your home, and most homeowners have never once opened their CC&Rs, what else is in that document that nobody ever told you about? And more importantly, what are they already enforcing that you've been paying for without knowing you didn't have to?